Hello. We'll be discussing the 13th chapter of Aristotle's Art of Rhetoric. In this chapter, Aristotle discusses the concept of law. Specifically, he discusses two types of law in his view. The first type is called natural law, and the second type is unnatural law or written law. Written law is the law that is constitutional, agreed upon and established by a given nation, or in this case, the city-states that he inhabited. And this law is intended to address cases that are not forgivable, they're not pardonable, and they can't be arbitrated outside of the courtroom. Natural law, on the other hand, is the law that everyone can agree upon, but they can't necessarily define it. It's a law that eludes logic somewhat, but appeals to the heart. Empedocles said of the natural law that it's an all-embracing law. Through the realms of the sky, unbroken it stretcheth, and over earth's immensity. And Homer said of natural law, not of today or yesterday it is, but lives eternal. None can date its birth. Those two statements are almost mystical or religious in nature, or metaphysical in nature, something that does not have a beginning or an end, is everywhere all at once, and is something that is not amenable to change. That is the natural divine justice according to Aristotle. When a person does a wrong or commits a violation of the law, there needs to be several conditions for that violation to hold. The first condition is that harm must be done, and the harm must be involuntary, so the victim must not want the harm or will the harm. It must be done against their will. The second thing is that the act needs to be intentional. The wrongdoer needs to have evidence, or there needs to be evidence of it being an intentional wrong. And that intention can either be something that is reasoned, or that's something done from passion. Passion being a motive, or as opposed to deliberate choice. Also, a wrong can be done to an individual, and it can be done to a community. Wrongs to a community are often acts of omission as opposed to commission. For example, not paying taxes or refusing to enlist in the army or join the draft are seen as acts against the community. These acts, when taken en masse, will have disastrous effects to each individual, and that's one way of determining whether an act is a crime to the community. Aristotle gives a few examples of reframing acts as crimes or as unintentional crimes or mistakes. So, someone can be accused of stealing a thing and he can say, actually, I just took it. Someone can be accused of treason, but actually they can respond, actually, I was just communicating with the enemy. There weren't any treasonous intentions in my action there. So these injuries can harm both the written law and the unwritten law. The written law is easy to arbitrate, it's defined, but the unwritten law is harder to pin down. Aristotle says the unwritten law's purpose is to fill the defects in the written law. The defects are twofold. The first are defects where a concept can't easily be defined, or it can't be put into words, it's ineffable, but people agree on the wrong. The second is where there are issues of specifically defining something, so the possession of a weapon, for example. Aristotle says it would be too burdensome to list all the infinite configurations of objects in terms of their size and their weight and their bluntness and sharpness and their material. To list all of those objects would be too burdensome. In fact, the permutations of all those factors would be verging on the infinite. In this instance, we rely on the unwritten law to fill in the gaps. It's the intuition that is a necessary part of determining whether wrong has been done. Aristotle then brings up the concept of equity. Equity is the process of interpreting the law in a just way. For example, he gives the example of a person that strikes another person with a ring on their hand. It wouldn't be equitable to prosecute that individual for using a weapon, because it's clear the ring wasn't intended to be a weapon, and the individual may not have been aware that he had a ring on his hand before he struck that person in the first place. So, while the ring may have added injury, the context here doesn't necessitate prosecuting that person in the written law with harming another with a weapon, as opposed to just their fists or their limbs. And he defines this in a very logical way. Equity must be applied to forgivable actions, and that means that the person needs to distinguish between a criminal act, where the intent is there and the intended effect happened, so they intended to do something and the effect they also intended. Misfortune is when someone does something and there's an unexpected result, and then error of judgment is where someone does something and they intend for the effect to happen, but their underlying intentions weren't wicked, they weren't bad. Finally, Aristotle says that we need to be merciful in our appraisal of a criminal act, and that means we need to be cognizant of the weakness of human nature, is his phrase. Think less about the written law, the word of the law, and more about the context here, the whole story and not just the detail. Who the individuals, where they came from, who they were, what they are, the balance, what they've done more broadly in their lives, and so forth. Things need to be seen not in isolation, but as a gestalt. And finally, Aristotle says it's preferable to settle disagreements by arbitration to judgment. Arbitration being the more equitable manner, because judgment is a strict form of arbitration that is blunt in nature, and Aristotle says that actually disputes should be settled by negotiation, which is something that is mutually agreed upon, rather than judgment, whereby judgment is something that is coercive. The person that's being convicted is forced to suffer the punishment. whereas in a arbitration, both parties agree that this is the right way to go. So much for law. Thank you.